A constitutional dispute has emerged ahead of the governorship election in Bayelsa State. This follows the disqualification of the candidate of the All Progressives Congress, Timipre Silva, by a federal high court in Abuja. Justice Donatus Okorowo gave the verdict on the grounds that Silva has been sworn in as governor twice and has already served for 5 years. Arise correspondent Godfrey Eshemoge reports.
Justice Donatus Okorowo held that Silva, having been sworn in twice and ruled for 5 years as governor of Bayelsa State, it will amount to a breach of the 1999 Constitution if allowed to contest again on the platform of the All Progressives Congress, APC. A member of the APC had asked the court to order electoral body INEC to delete Silva's name from the list of candidates. He says that by the provision of Section 182, subsection 1b of the 1999 Constitution as amended, Silva isn't qualified to contest because he was elected in April 2007 and May 2008. While citing the Court of Appeal judgment in April 2008 that nullified his election in 2007, the former Minister of State for Petroleum maintains he is within his constitutional and legal rights to contest the Bayelsa State governorship election. In a swift reaction, the Director of Media and Publicity for the APC Bayelsa Governorship Campaign Council, Perry Tukwe, says a team of lawyers have approached the Court of Appeal expressing confidence to overturn the judgment of the Federal High Court. The party says there is a practice directive by the Supreme Court that all pre-election matters be heard in the state where the primaries took place, but in this particular instance, the suit was filed in Abuja. Godfrey Eshemoge, Arise News.
Joining us now from Bayelsa State is Stanley Damabide, Director, Legal Clearance, Bayelsa All Progressives Congress Governorship Campaign Council. Good morning, Mr. Damabide, and welcome to the morning show.
Good morning. It's my pleasure to be with you this morning.
Damabide, we understand that the APC has since gone to the Court of Appeal to appeal the ruling of the Federal High Court in the matter of Chief Timipre Silva. Now, the appeal is based on 3 things we understand. One, the jurisdiction of the court. Dr. IGSAN is saying, in the appeal that, the court cannot inquire into party matters. The second issue is the locus standi of the respondent, who was not part of the primaries. And the third was the wrongful assessment of evidence by witnesses. Now, how strong is your party on these 3 grounds, considering the fact that the learned judge was making a point that if Timipre Silva were to be allowed to do another 4 years, he will have spent 4 extra years, making a total of 9 years, when the Constitution says you can only have 2 full terms of 4 years each. And that also he had been sworn in twice in the past. You are the Director Legal Clearance. Can you make a case since no hearing has been fixed yet for the appeal?
Yes, I'm not just going to make a case. I'm going to try to set the facts straight as they are. Let me say that the grounds of appeal are as solid as the Rock of Gibraltar, if not stronger, and that the unnaturalness, the seemingly illogical elements surrounding this judgment, it's really worrisome, to the average legal mind, But I'll go straight to focus on the points that you raised. Firstly, what are we talking about? We are talking about a situation where, contrary to clear provisions of the law, an interpretation was given. It is not in dispute, even the adverse party will admit that this is clearly a pre-election matter. And now the law has changed, the 1999 Constitution and the Extant Electoral Act, on the point of who can approach the courts to query party primary elections. So let's just start from that. This plaintiff, this claimant, was he legally competent to challenge the APC primary election given the extant provisions of the law? The answer is a big no. Because the law says, look, you must have been an aspirant in a primary election of a particular political party before you can have the competence to challenge the process. And so it was shameful and shocking that despite these clear provisions, we could get a pronouncement in the manner that it came. And I think one big mistake was made with regards to the pronouncement that was made. In law, you interpret situations according to the law. You know, there are de facto circumstances and there are also de jure circumstances. If an act or a period counts for nothing within the law, it remains so, despite the fact that that nothingness may, on the bare facts, appear to be something. I'm talking about the computation of time that Chief Timipre Silva would have ruled if he wins the forthcoming gubernatorial elections. You had a process in which, yes, by fact, he was in occupation of the office, but which by law was pronounced to be a nullity in all forms. And so in law, that wouldn't count any further. And you don't need a rocket science brain in law to understand the basic interpretation of that fact. And there are many precedents that were begging for this court of first instance to draw from. Not too long ago, we had the former President Goodluck Jonathan scenario, whereby mathematical computation, had he won, it would have been in office for a time longer than 8 years, by fact, not by law. And then the court said, hey, we must understand this in accordance with the provisions of the law. And it gave appropriate interpretation in that circumstance. It is quite worrisome that at this time that so much smear is befalling the judiciary, we that are ministers in the temple of justice will have this added burden of trying to explain why things are happening this way. But more importantly for us is the fact that we still have confidence in the judiciary. We do not have an option. And we're looking forward to an appellate process that will swiftly reverse, this trend that has been created by this judgment. All
right. Thank you, Mr. Damabide. Just one question. You'd compared this situation to that of the former president, Goodluck Jonathan. But one of the things that the judge ruled is the fact that your candidate has participated in 2 elections prior. Former President Goodluck Jonathan had only participated in the capacity of running for the presidency in 1. The first time was him having to step in because the president had passed away, unfortunately. But in this case, Mr. Timipre Silva has participated in 2 elections. It means that he's going to be participating in his 3rd election for being governor. So there's a bit of a difference there. Can you explain that further in terms of your case? And also the fact that, you talked about the number of years, but participation in elections, your chair has said that despite this, you continue with your campaign process. You have only 1 month to go. Today makes it 1 month to the elections. What are the plans?
Yes. Well, the plans are that, when you see slight irritants or slightly irritating issues based on your understanding of the law and the facts, you don't elevate them to the pedestal where they will be troubling to you. I must admit that the implications of this judgment, particularly on the misinformed, might be a little troubling, the misinformed faithful of the APC. But we're going to address that because the law is consistent on certain areas. But quickly, let me address your issue of having participated in 2 previous elections.
Yes.
Were there challenges to these 2 previous elections? Were there court pronouncements on these two previous elections. You remember quite quickly that the first one got to the Court of Appeal, which was then the last court with regards to gubernatorial disputes, gubernatorial election disputes. And the court nullified the said first election. I said, look, nothing did hold in the eyes of the law, and so it has to be done properly. If a process has been nullified by the court of law, then de jure-wise, before the eyes of the law, it didn't hold. This common saying in law that you can't place nothing on something and expect it to stand will immediately come to the fore. And that's the scenario with regards to the first election. It shouldn't be troubling. I've had comments also with regards to the fact that you can't take oath of office more than a given period of time, as well as the oath that was taken on the basis of the first declaration that has been nullified by a court of competent jurisdiction, flows with all of this. So, nothingness has been pronounced on one of the processes, and in law, that will so remain. And no court should try to dig out what has been buried and properly so. It's just it. And I just hope you understand the point I'm trying to make here. That is the scenario with regards to this situation. And we have no worries at all that it's going to be a smooth sail when the appellate and apex court ultimately, I believe is going to get there, makes pronouncement on this case.
Damabide, I know this matter is already going on appeal, but when you stress the point about the nullification of Chief Silva's first term in office, which was from May 2007 to April 2008, and you are quoting the principle, ex nihilo nihil fit, right? Nothing stands or nothing. Does that nullification extend to functions, decisions taken by Timipre Silva as governor during that period? Because if we stretch the argument, will you say everything he did was declared by the court as nothing when that election was nullified, although he subsequently won the other election that was ordered by the court? Can you explain that to us? Because that's what you are taking to the Court of Appeal.
Firstly, let me commend your understanding of Latin and your use of it in this circumstance. I'll go further to say that the scenario that we're talking about, I've been saying this repeatedly, that de facto scenarios may not, when explained, match with de jure settings. Now, this is the point with regards to this. In that pronouncement that nullified the first process, yes, by fact, cannot erase that certain things were done. But that's a fact of the case. It doesn't prejudice the law with regards to what is happening. I know that there are some instances where persons, believed to have been properly elected, had the elections nullified, and a further order was made also for them to refund emoluments received within that period. And that's the law trying to stretch it further to say, hey, look, there must be a balance with regards to the injustice that this situation is going to create. But in this setting, let's not forget that the nullification of the process, the first one, was not tied to the acts done by Chief Timipre Silva. And the court didn't see any reason to make some quasi-punitive pronouncements as to nullifying contracts awarded and payments received and all of that for that period. Because the organizers of the elections were the ones that were held not to have done what was, expected to be done. And so in that setting, despite the presence of facts that, look, there couldn't have been a vacuum within this period and certain administrative actions had to be taken, the fact that, the nullification process cannot be tied to the actions of Timipre Silva will not attract, certain anticipated punishments. And since it didn't come, that is the case. And I don't think we should argue too much on that. I think, yes, unless you come to the understanding that the law interprets situations that might appear, not very related or explanatory or factual situations in given settings.
On that note, Stanley Damabide,
you will then be able to understand.
Yes, on that note, we'd like to thank you very much for joining us on The Morning Show.